I was halfway up the ladder when I heard the shriek that would change my next 6 months. "What do you think you are doing?" The voice cut through the pleasant Saturday morning air like a buzzsaw through butter. I looked down from my position 12 feet up to see a woman marching across my front lawn in Scottsdale, Arizona. Her blonde hair sprayed into submission, and her face twisted into an expression of pure outrage. I steadied myself on the ladder, gripping the flagpole I had been installing into the bracket mounted on my house. "Installing a flagpole," I called down, trying to keep my voice friendly despite the interruption. "Beautiful morning for it, don't you think?" The woman stopped at the base of my ladder, hands planted firmly on her hips. She was probably in her early 50s, wearing yoga pants that suggested she had just come from a class, though the designer purse slung over her shoulder probably cost more than my first car. "You cannot install that," she said, jabbing a finger at my flagpole. "It is completely against HOA regulations." I climbed down the ladder slowly, my tool belt jangling with each step. When I reached the ground, I extended my hand. "I am sorry, I do not think we have met. I am Marcus Thompson. I bought this place about 3 months ago." She ignored my outstretched hand. "I am Patricia Henderson, president of the Saguaro Springs HOA board, and I know exactly who you are, Mr. Thompson. What I do not know is why you think you can install a flagpole without board approval." I glanced back at my house, a nice 3-bedroom ranch-style home I had purchased after my discharge from the Marines. The bracket was already mounted, and I had spent the better part of the morning making sure everything was level and secure. I was not aware I needed approval to fly the American flag on my own property. Patricia's laugh was sharp and humorless. "Everything requires approval in Saguaro Springs. The color of your shutters, the plants in your garden, and especially structures like flagpoles. Did you not read the CC and Articles when you purchased your home?" I had read them, actually. All 73 pages of covenants, conditions, and restrictions that governed life in this suburban community, but I had also done my homework on something else. "I read them," I said calmly. "I also read the freedom to display the American Flag Act of 2005. Patricia's eyes narrowed. "I do not care what act you read. This is a private community with rules. Remove the flagpole or I will be forced to take action." "What kind of action?" I asked, genuinely curious now. "Fines," she said crisply. $50 per day until you comply. And if you refuse to pay, we can place a lien on your property." She pulled out her phone and snapped a photo of my ladder and the partially installed flagpole. "Consider this your verbal warning. You will receive written notice within 48 hours. She turned on her heel and marched back across my lawn, leaving small divots in the grass from her expensive sneakers. I watched her go, feeling my jaw clench. I had served 2 tours overseas, had been shot at and mortared, had watched friends die defending the flag I wanted to display. And now some HOA president was telling me I could not hang it on my own house. I climbed back up the ladder and finished installing the flagpole. The written notice arrived exactly 48 hours later, on Monday morning. I found it tucked into my screen door when I got home from work at the telecommunications company, where I had landed a job as a network technician. The letter was printed on expensive cream-colored paper, with the Saguaro Springs HOA logo embossed at the top. "Dear Mr. Thompson," it began, in a tone that suggested the greeting was merely a formality. "It has come to the attention of the Saguaro Springs HOA Board of Directors that you have installed an unauthorized flagpole on the exterior of your residence, located at 4782 Desert Bloom Drive. This installation is in direct violation of Section 7.3 of the Community CC and Articles, which states that no exterior modifications may be made without prior written approval from the Architectural Review Committee. I skimmed through 2 more paragraphs of legal jargon before getting to the meat of it. I was being fined $50 per day starting from the date of installation, which they had helpfully noted as Saturday, March 1st, 2026. I was given 15 days to remove the flagpole and submit photographic evidence of its removal, or face additional penalties, including potential legal action. I set the letter down on my kitchen counter and looked out the window at the flag waving gently in the evening breeze. It was a standard 3x5-foot American flag, nothing ostentatious or unusual. The flagpole itself was a simple 6-foot aluminum pole mounted at a 45-degree angle from the wall next to my front door. I had installed it properly, following all the manufacturer's instructions, and had even taken care to position it so it did not block any windows or interfere with the siding. I pulled out my laptop and started researching. The Freedom to Display the American Flag Act was real, passed by Congress and signed into law by President Bush. It specifically prohibited homeowners' associations from restricting the display of the American flag, with some reasonable limitations. The flag had to be displayed in a manner consistent with federal flag code. It could not be larger than certain dimensions, and the association could impose reasonable restrictions on the size, place, and manner of display, but they could not ban it outright. From what I could tell, my installation met all the requirements. The flag was the right size. I was displaying it properly according to flag code, taking it down at night and in bad weather, and the pole was mounted in a reasonable location. The HOA did not have a leg to stand on. I drafted an email to Patricia Henderson, carefully citing the relevant federal law and explaining my position. I kept it professional and factual, avoiding any hint of anger or accusation. I hit send at 8:30 p.m. and went to bed feeling confident that this would be resolved quickly once the board understood the legal situation. I was wrong. Patricia's response arrived in my inbox the next morning while I was eating breakfast. It was curt and dismissive. Mr. Thompson, the federal law you cite does not override our community's legitimately established covenants. The Architectural Review Committee exists to maintain property values and aesthetic standards for all residents. Your flagpole is an eyesore and was installed without permission. The fines stand. You have 13 days remaining to comply. Regards, Patricia Henderson, HOA President. An eyesore. She had called the American flag an eyesore. I felt my face flush with anger as I read the email a second time. I had expected resistance, but I had not expected such blatant disregard for federal law. I forwarded the email to myself at work and spent my lunch hour that day researching attorneys who specialized in HOA disputes. Most of the lawyers I contacted wanted retainers of $3,000 to $5,000 just to take the case. As a recent home buyer, I did not have that kind of money lying around. I was about to give up when I found a small practice in Phoenix that advertised free consultations for military veterans. The attorney, a man named Robert Chen, agreed to meet with me that Thursday evening. Robert's office was in a modest building near downtown Phoenix, sandwiched between a bail bondsman and a tax preparation service. He was younger than I expected, probably in his mid-30s, with close-cropped black hair and wire-rimmed glasses. His office walls were covered with framed certificates and photos of him in Army dress uniform. "Mr. Thompson," he said, shaking my hand firmly, "thank you for your service. Marines, right?" "Yes, sir," I said. "2 tours, Iraq and Afghanistan." "Army myself," he said, gesturing to a chair across from his desk. "1 tour in Afghanistan, got out in 2019 and went to law school." He settled into his own chair and pulled out a yellow legal pad. "Now, tell me about this flagpole situation." I walked him through everything. The installation, Patricia's confrontation, the letter, the fines, and her dismissive email. I showed him photos of my flagpole and a copy of the CC and Articus. He listened carefully, taking notes and occasionally asking questions about specific details. When I finished, he leaned back in his chair and tapped his pen against the legal pad. "This is pretty straightforward," he said. "The freedom to display the American Flag Act is clear, and your installation appears to meet all the reasonable requirements." The HOA is absolutely in the wrong here. Relief flooded through me. "So what do? We send them a demand letter," Robert said. "I will cite the relevant federal statute, explain why their actions are illegal, and demand that they rescind the fines and cease any further action against you." Most HOAs back down once they realize they are facing actual legal consequences. "And if they do not back down," I asked, "then we file suit in federal court." He pulled out a fee agreement and slid it across the desk. "My rate is $200 an hour, but I cap veteran cases at $2,000 unless things get really complicated. If we win, which I am confident we will, we can seek to have the court order the HOA to pay your legal fees." $2,000. It was a lot of money, but it was better than the alternatives. I thought about Patricia's face when she called my flag an eyesore. I thought about all the mornings I had watched that flag being raised at military bases across the world, and all the soldiers who had died defending it. "Let's do it," I said, and signed the agreement. Robert sent the demand letter the next day. It was 4 pages of dense legal prose that basically boiled down to, "You are breaking federal law, stop it now, and cancel the fines or we will sue you." He sent it via certified mail to the HOA's registered agent and copied Patricia Henderson directly. We waited. The 15-day deadline came and went. My flag continued to fly, and I continued to receive daily notices from the HOA informing me that my fine balance was now $750, then $800, then $850. On day 17, a different letter arrived. This one was from a law firm in Scottsdale called Morrison, Blake and Associates. It was addressed to me but also copied Robert as my attorney of record. "Dear Mr. Thompson," it began, in the same artificially polite tone as Patricia's previous correspondence. "This firm represents the Saguaro Springs Homeowners Association in the matter of your unauthorized flagpole installation. We write to inform you that the HOA board has reviewed your contentions regarding federal law and finds them unpersuasive. The Freedom to Display the American Flag Act contains provisions for reasonable restrictions, and the board has determined that your installation violates these reasonable restrictions." The letter went on to argue that requiring advance approval for any exterior modifications was inherently reasonable, that the board had the right to evaluate each request individually to ensure community standards were maintained, and that my failure to seek such approval constituted a violation regardless of what I was displaying. "Furthermore," the letter continued, "the board notes that several other residents have flags displayed in their yards or attached to their homes, all of which were properly approved through the Architectural Review Committee. Your refusal to follow the same process creates an unfair precedent and undermines the authority of the board to govern the community effectively." The letter concluded by demanding that I remove the flagpole within 7 days or face additional legal action, including the possibility of seeking an injunction to force removal and pursuing collection proceedings for the now $1,000 in accumulated fines. I forwarded the letter to Robert immediately. He called me within an hour. "They hired Morrison Blake," he said, and I could hear the tension in his voice. "That is a big firm, expensive." "Is that bad for us?" I asked. "Not necessarily," he said. "But it means they are serious about fighting this. Most HOAs would have backed down by now." They must have some deep pockets, probably from community assessment fees. So what is our next move? We file the lawsuit, Robert said. I will draft the complaint tonight. We are going to federal court. The complaint was filed on March 25, 2026, in the United States District Court for the District of Arizona. The case was titled Marcus Thompson v. Saguaro Springs Homeowners Association, Inc., and ran to 15 pages of legal arguments. Robert laid out the facts clearly. I was a veteran who wanted to display the American flag. I had done so in compliance with all reasonable restrictions, and the HOA was violating federal law by attempting to force me to remove it. We were not just asking the court to rule in my favor. We were asking for declaratory relief, stating that my flagpole was legal, injunctive relief preventing the HOA from taking any action against me, and reimbursement of my legal fees under the fee-shifting provisions that applied to federal civil rights cases. The HOA had 21 days to respond. During that time, the fines continued to accumulate. Patricia sent me a smug email informing me that my balance was now $1,500 and that a lien would be placed on my property if I did not pay by the end of April. I did not respond. Robert had advised me to cut off all direct communication with the board and let the lawyers handle everything from this point forward. It was harder than it sounded. Every time I pulled into my driveway and saw my flag waving, I felt a mixture of pride and frustration. This should not have been so complicated. The HOA's response arrived on April 15th, right at the deadline. It was a motion to dismiss, arguing that the court lacked jurisdiction because this was a private contract dispute, not a federal civil rights matter. Morrison Blake was trying to get the case thrown out before it even got started. Robert filed our opposition brief a week later. The arguments went back and forth like a tennis match, volleys of legal citations and case law precedents. The judge, a woman named Margaret Keller who had been appointed to the federal bench in 2018, scheduled a hearing on the motion to dismiss for May 2nd. I took the morning off work to attend. The courthouse in downtown Phoenix was an imposing modernist structure of concrete and glass. I met Robert in the lobby, and we went through security together. He was carrying a leather briefcase stuffed with papers and wore a crisp navy suit that made him look older and more authoritative. "Just stay calm and let me do the talking," he said as we rode the elevator up to the courtroom. Oral arguments on motions like this are usually pretty dry. The judge has read all the briefs already. This is just a chance for both sides to emphasize their strongest points. The courtroom was smaller than I expected, with wooden benches for spectators and a raised platform where Judge Keller would sit. The HOA's attorneys were already there, 3 of them in matching gray suits. Patricia Henderson sat in the front row behind the defense table, her arms crossed and her expression sour. Judge Keller entered promptly at 10 a.m., and we all rose. She was in her early 60s with short silver hair and a no-nonsense demeanor. She settled into her chair, adjusted her reading glasses, and looked down at the papers in front of her. "This is the matter of Thompson versus Saguaro Springs HOA," she said. "I have reviewed the motion to dismiss and the opposition. Counsel for the defendant, you may proceed." The lead attorney for the HOA, a silver-haired man who introduced himself as Thomas Morrison, stood and approached the lectern. "Thank you, Your Honor. This case is fundamentally about contract law, not civil rights. Mr. Thompson voluntarily entered into a binding agreement when he purchased his home in Saguaro Springs. That agreement requires him to seek approval for exterior modifications. He failed to do so. The HOA's enforcement of this provision is entirely proper and does not implicate federal law." He continued for another 10 minutes, arguing that the Freedom to Display the American Flag Act only prohibited outright bans on flags, not reasonable procedural requirements like obtaining advance approval. He cited several cases from other jurisdictions where courts had sided with HOAs in similar disputes. When he finished, Judge Keller turned to Robert, counsel for the plaintiff. Robert stood, and I noticed his hands were completely steady as he gathered his notes. Your Honor, the defendant's argument fundamentally misunderstands the scope of the federal statute. The Freedom to Display the American Flag Act was passed specifically because HOAs across the country were using procedural requirements exactly like this one to prevent homeowners from displaying the flag. Congress determined that this was unacceptable. He went on to explain that requiring advance approval gave the HOA effectively unlimited discretion to deny flag displays for any reason, even if they dressed it up as concerns about aesthetics or procedure. He pointed out that my flagpole met every objective standard for a reasonable display, and that the HOA had never articulated any legitimate reason why my specific installation was problematic. Moreover, Your Honor, Robert continued, this is not a mere contract dispute. When an HOA uses its authority to violate federal law, that creates federal question jurisdiction. Mr. Thompson has a federally protected right to display the American flag. The defendant is attempting to infringe that right. This court has jurisdiction and should deny the motion to dismiss. Judge Keller listened carefully, occasionally jotting notes. When Robert finished, she asked a few pointed questions about the specific language in the federal statute and how it applied to procedural versus substantive restrictions. Robert handled each question smoothly, and I could see Thomas Morrison's expression growing more troubled with each exchange. Finally, Judge Keller announced she would take the matter under advisement and issue a written ruling within 2 weeks. We were dismissed. Outside the courthouse, Robert was cautiously optimistic. I think that went well, he said. Judge Keller seemed skeptical of their jurisdiction argument, but you never know for sure until the ruling comes down. The ruling arrived on May 9th. Judge Keller denied the motion to dismiss in a scathing 8-page opinion. She found that the case clearly presented a federal question, that my claims were plausible on their face, and that the HOA's procedural requirements appeared to be the exact kind of end run around federal law that Congress had intended to prohibit. The defendant cannot avoid federal scrutiny simply by cloaking its restrictions in procedural language, she wrote. If requiring advance approval serves as a de facto ban on flag displays, or if that approval process is applied in an arbitrary or discriminatory manner, then it violates the plain language and intent of the Freedom to Display the American Flag Act. She ordered the case to proceed to discovery, where both sides would exchange documents and take depositions. The trial was tentatively scheduled for September. Robert called me with the news, his voice excited. This is huge, Marcus. We just cleared the biggest hurdle. Now they have to actually defend their actions on the merits, and I do not think they can. But the HOA was not done fighting. Over the next 3 months, Morrison Blake filed motion after motion seeking to limit what evidence we could introduce, what questions we could ask in depositions, and what legal theories we could pursue. Each motion required a response, which meant more hours of Robert's time and more money out of my pocket. By the end of May, my legal bills had reached $800. By the end of June, I was at $1,300. The HOA, meanwhile, continued to send me monthly statements showing my fine balance growing. It was now over $4,000, and Patricia sent a formal notice that a lien had been recorded against my property. I tried not to think about what would happen if we lost. I focused on work, kept my lawn immaculate, and made sure my flag was always displayed properly. Some of my neighbors started to notice the dispute. A few offered quiet words of support. One older veteran who lived 3 houses down even came by to shake my hand and tell me he had my back. But others clearly sided with the HOA. I noticed some people crossing the street to avoid me when I was out front. At a neighborhood barbecue in early July, one woman I barely knew made a pointed comment about people who think they are above the rules. I left early. The depositions began in mid-July. Robert deposed Patricia Henderson first, and I was allowed to attend. We gathered in a conference room at Morrison Blake's offices, a gleaming high-rise in Scottsdale with views of Camelback Mountain. Patricia arrived wearing a cream-colored business suit and carrying a designer handbag. She sat across from Robert while a court reporter set up her stenography machine. Thomas Morrison sat next to Patricia, ready to object to any inappropriate questions. Robert started with basic background questions about the HOA's structure, the number of board members, and how decisions were made. Patricia answered in a clipped, professional tone, clearly coached by her attorneys. Then Robert moved to the heart of the matter. Mrs. Henderson, when you first saw Mr. Thompson installing his flagpole, what was your reaction? I was concerned that he had not followed proper procedure, Patricia said smoothly. Were you concerned about the flag itself or just the procedure? Robert asked. The procedure, Patricia said. Our community has standards. Had you ever approved a flagpole installation before? Robert asked. Patricia hesitated. We have approved flag displays, yes. How many flagpole installations specifically? Robert pressed. I would have to review the records, Patricia said. Robert produced a document from his briefcase. I am showing you what has been marked as Exhibit 7, which is a list of all architectural approval requests for the past 5 years. Can you point to a single flagpole approval on this list? Patricia scanned the document, her lips pressed into a thin line. I do not see any. Is that because no one has requested approval for a flagpole? Robert asked. I suppose so, Patricia said. So you have no idea whether the board would have approved Mr. Thompson's flagpole if he had asked, correct? We would have evaluated it according to our standards, Patricia said defensively. What standards? Robert asked. What specific criteria would you have used? Patricia looked to Thomas Morrison, who cleared his throat. This calls for speculation. She cannot testify about a hypothetical review process. Your Honor, Robert began, then caught himself. We were not in court, there was no judge present at a deposition. He shifted tactics. Mrs. Henderson, in your email to Mr. Thompson, you called his flagpole an eyesore. Do you remember writing that? Patricia's face flushed slightly. I may have used that term. You called the American flag an eyesore, Robert said flatly. I called the flagpole installation an eyesore, Patricia corrected. The manner of installation, not the flag itself. What specifically about the installation was an eyesore? Robert asked. Was the pole crooked? No, Patricia admitted. Was it too large? It was larger than I would prefer, Patricia said. But it is a standard 6-foot flagpole displaying a 3x5 flag, which is explicitly protected under federal law, correct? I do not know the specific dimensions of federal law, Patricia said stiffly. Robert spent another hour pressing her on the details of the board's decision-making process, their awareness of federal flag protection laws, and whether any legitimate aesthetic concerns justified their actions. Patricia grew increasingly flustered, and Thomas Morrison made frequent objections that Robert noted for the record. When it was over, Robert seemed pleased. She did not help her case, he told me as we walked to our cars. The eyesore comment is going to be devastating in front of a jury if it comes to that. But he also warned me that we still had months to go and litigation was unpredictable. They might try to settle, he said, especially once they see how weak their position is. But Morrison Blake is making a lot of money dragging this out, so they might push for trial. I was deposed the following week. Thomas Morrison asked me detailed questions about my military service, my reasons for wanting to display the flag, and my understanding of the HOA rules when I bought my house. I answered everything honestly, explaining that I had researched the federal law specifically because I knew HOA restrictions were common, and I wanted to make sure I was protected. "So you knew there might be a conflict," Morrison said, leaning forward slightly. "I knew the HOA might try to stop me," I said. "That is why I made sure I was following federal law." "Did you ever consider just asking for permission?" Morrison asked. "I did not think I needed permission to display the American flag on my own home," I said. "I served 2 tours defending that flag. I did not expect to have to fight for the right to fly it in my own front yard." Morrison pressed me on the cost of the litigation, suggesting that I was being unreasonable by not simply complying with the HOA's request. Would it not have been simpler to just follow the rules? He asked. "The rules are unconstitutional," I said. "Following them would mean giving up my federally protected rights." After 3 hours, the deposition ended. Robert said I had done well, but I felt exhausted and drained. This whole process was taking a toll. I was spending my evenings reviewing legal documents instead of relaxing. I was spending money I did not really have to fight for something that should have been simple. And I was living under the constant stress of wondering what would happen if we lost. August brought more delays. The HOA filed a motion for summary judgment, arguing that even if we were right about the law, there were no disputed facts and the judge could rule in their favor without a trial. Robert filed our own motion for summary judgment, arguing the exact opposite, that the facts clearly showed the HOA had violated federal law and we deserved to win. Judge Keller scheduled another hearing for August 23rd. This time, I did not bother taking off work. Robert assured me that the oral arguments would be similar to the motion to dismiss hearing, and there was no need for me to be there. He called me that afternoon with surprising news. The judge pressed Morrison pretty hard about the eyesore comment, Robert said. She basically asked him how calling the American flag an eyesore could possibly be consistent with the HOA's claim that this is just about procedure. He did not have a good answer. "So what happens now?" I asked. "She is taking both motions under advisement," Robert said. But here is the interesting part. After the hearing, Morrison approached me and asked if we would be willing to discuss settlement. My heart jumped. "Settlement? What kind of settlement?" "He did not give specifics," Robert said. "Just asked if we would be open to talking. I told him I would discuss it with you." We talked it over for the next week. Robert explained that settlement could mean a lot of things. They might offer to let me keep the flagpole if I paid some portion of the fines. They might offer to waive the fines if I agreed to relocate the flagpole to a different part of my property. They might offer nothing at all and just be fishing to see what we wanted. What do I want? I asked Robert during a phone call on August 29th. "That is up to you," Robert said. "If we go to trial and win, you will likely get everything: the right to keep your flagpole where it is, cancellation of all fines and reimbursement of your legal fees. But trials are risky. Juries can be unpredictable even when the law is on our side." I thought about it for a long time. I thought about the stress, the money, the neighbors who now avoided me. I thought about Patricia's face when she called my flag an eyesore. And I thought about the flag itself, waving outside my house every morning when I left for work. "I want them to admit they were wrong," I said finally. "I want the flagpole to stay where it is, I want all the fines canceled, and I want them to pay my legal bills. If they are willing to do that, I will settle. Otherwise, we go to trial." Robert conveyed my terms to Morrison. 3 days later, on September 1st, we received a counteroffer. The HOA would allow the flagpole to remain, would cancel all outstanding fines, but would only pay half of my legal fees. They wanted me to sign a non-disclosure agreement preventing me from talking publicly about the dispute. No, I said immediately when Robert read me the offer. I am not signing an NDA. They tried to bully me into taking down the American flag. If I agree to stay quiet, they will just do the same thing to the next veteran who moves into the neighborhood. Robert went back to Morrison with my rejection. Morrison came back with a revised offer, full legal fees, but only if I agreed to the NDA. Still no, I said. This is not about the money, Robert. It is about the principle. They need to be held accountable. On September 8th, Judge Keller issued her ruling on the summary judgment motions. She denied the HOA's motion and granted ours in part. In a detailed 20-page opinion, she found that my flagpole display was clearly protected under federal law, that the HOA's procedural requirements constituted an unreasonable restriction, and that their enforcement actions were unlawful. However, she stopped short of awarding me legal fees at this stage. The question of attorney's fees is more appropriately resolved after trial or settlement, she wrote. The court finds that plaintiff is entitled to display his flagpole, and defendants are enjoined from taking any further action to prevent such display or to collect fines related thereto. The parties shall proceed to trial on the remaining issue of damages, including attorney's fees. It was a huge victory, but not a complete one. The flagpole could stay, the fines were gone, but we still had to convince a judge or jury to award my legal fees. The next settlement offer came 2 days later. Morrison called Robert and proposed a meeting at a neutral location to discuss resolution. We agreed to meet at a coffee shop halfway between Phoenix and Scottsdale on September 12th. I arrived early and sat at a corner table nursing a black coffee. Robert showed up 10 minutes later, followed shortly by Thomas Morrison and another attorney from his firm. Notably, Patricia Henderson was not present. "Mr. Thompson," Morrison said, shaking my hand with a firm grip, "thank you for meeting with us. I think we can resolve this matter to everyone's satisfaction." We sat down, and Morrison pulled out a folder. "My clients have reviewed Judge Keller's ruling carefully. While they disagree with some of her legal conclusions, they recognize that continuing to litigate this matter is not in anyone's interest." "What are you proposing?" Robert asked. "Full capitulation," Morrison said simply. "The flagpole stays. All fines are formally canceled and removed from Mr. Thompson's account. The lien on his property is released immediately. And we pay his legal fees in full." I felt a surge of triumph but kept my expression neutral. "What about the NDA?" I asked. Morrison glanced at his colleague, then back at me. "We would prefer that the terms of the settlement remain confidential, but we understand your concerns. We are willing to forego the NDA on one condition. The settlement agreement will include a clause stating that both parties engaged in good faith negotiation and that the HOA is resolving this matter in the interest of community harmony, not as an admission of wrongdoing." Robert looked at me. I considered it. They were giving me everything I wanted materially, but they did not want to admit they were wrong. The language about community harmony was just face-saving nonsense. "Will there be an apology?" I asked. Morrison hesitated. "What kind of apology?" "A written apology from the board, acknowledging that my flag display was lawful and that they should not have tried to force me to remove it," I said. "It does not have to say they were malicious or acted in bad faith, just that they made a mistake and they are sorry." Morrison excused himself and his colleague to make a phone call. They stepped outside for 15 minutes while Robert and I waited. When they came back, Morrison was nodding. "The board has agreed," he said. "President Henderson will provide a written letter of apology to be delivered to you along with the settlement agreement. The letter will acknowledge that your flag display was protected by federal law and express regret for the dispute. Then we have a deal," I said. The settlement agreement was finalized over the next week. Robert and Morrison exchanged drafts, negotiating minor points of language until both sides were satisfied. On September 19, 2026, I sat in Robert's office and signed the final version. The agreement was straightforward. The HOA acknowledged that my flagpole display was lawful under the Freedom to Display the American Flag Act. All fines totaling $4,500 were canceled. The lien on my property was released, and the HOA agreed to pay my legal fees, which Robert had documented at $1,890. Attached to the settlement agreement was a letter on HOA letterhead, signed by Patricia Henderson and the other 4 board members. It read, "Dear Mr. Thompson, the Board of Directors of the Sagaro Springs Homeowners Association writes to express our sincere regret regarding the dispute over your flagpole display. Upon further review and consultation with legal counsel, we recognize that your display of the American flag is protected by federal law, and that our attempts to require its removal were mistaken. We apologize for the stress and inconvenience this matter has caused you. As a veteran who has served our country with honor, you have every right to display the flag on your property. We hope that this resolution will allow us all to move forward as members of a unified community. The board is committed to ensuring that future flag displays by residents are handled in accordance with federal law. We thank you for your patience and your service. Sincerely, the Sagaro Springs HOA Board of Directors." I read the letter 3 times. It was not perfect. The language was still somewhat formal and legalistic, but it was an apology. They had admitted they were wrong. "How do you feel?" Robert asked as I set the letter down. "Relieved," I said honestly, "and vindicated." "You should be," Robert said. "You stood up for your rights when a lot of people would have just backed down. That takes courage." We shook hands, and I left his office with copies of all the signed documents. The HOA's check for $1,890 arrived by FedEx 2 days later. I deposited it immediately and paid Robert's final invoice. The official notification that the lien had been released came the following week. I logged into the county recorder's website and confirmed that my property was clear. The monthly fine statements stopped arriving. For the first time in 6 months, I felt like I could breathe, but the story was not quite over. On September 28th, I received an email from a reporter at the Arizona Republic, the main newspaper in Phoenix. She had somehow heard about the case and wanted to interview me for a story about HOA overreach and veterans' rights. I agreed, and the article ran on October 3rd under the headline, "Scottsdale Veteran Wins Right to Fly Flag After HOA Dispute." The article was fair and balanced, presenting both my perspective and a brief statement from the HOA's attorney about their commitment to following federal law. But it clearly portrayed me as the sympathetic party, a veteran who just wanted to display the flag he had fought for. The response was overwhelming. I received dozens of emails and Facebook messages from people thanking me for standing up to the HOA. Several veterans organizations reached out to offer support and asked if I would speak at events about the experience. A local VFW post even gave me an award for defending the freedom to display the American flag on the home front. But not all the attention was positive. Some of my neighbors in Sagaro Springs were angry that I had brought negative publicity to the community. One woman left a note in my mailbox accusing me of being a troublemaker who cared more about attention than community harmony. Another neighbor, someone I had never even spoken to, shouted at me from across the street that I should be ashamed of myself for making the neighborhood look bad. Patricia Henderson resigned as HOA president in mid-October. The board issued a terse statement thanking her for her service and announcing that the vice president would assume her duties for the remainder of the term. I never saw Patricia again. According to neighborhood gossip, she put her house on the market and moved to Sun City within a few months. The new HOA president, a retired engineer named David Martinez, reached out to me in early November. He called me on a Saturday morning and asked if I would be willing to meet with him for coffee. I was hesitant, given everything that had happened, but something in his voice sounded genuine. We met at the same coffee shop where I had negotiated the settlement with Morrison. David was in his early 60s, with gray hair and a weathered face that suggested he spent a lot of time outdoors. He shook my hand warmly and insisted on buying my coffee. "Mr. Thompson, I want to start by apologizing personally for how the board handled your flag situation," David said once we sat down. "I was on the board during that whole mess, and I should have pushed back harder against Patricia. She was convinced that maintaining control over every little detail was the only way to preserve property values. She would not listen to reason." "I appreciate that," I said carefully. "I also want you to know that we have revised our policies," David continued. "We now have explicit language in our architectural guidelines that flag displays protected by federal law are automatically approved. Residents do not need to submit an application. We have also added training for board members about federal and state laws that supersede HOA authority." "That is good to hear," I said, and I meant it. "Look, I know a lot of damage was done," David said. "You probably do not trust the HOA anymore, and I do not blame you, but I hope you will give us a chance to prove that we can do better. This is your home. You should feel welcome here." We talked for another hour. David told me about his own military service in the Navy during the Vietnam era. He explained that he had voted against Patricia's enforcement actions from the beginning, but had been outvoted by the other board members who deferred to her judgment. He seemed genuinely remorseful about the whole situation. Over the next few months, things gradually returned to normal. The neighbors who had been hostile either warmed up or at least stopped openly glaring at me. The neighbors who had been supportive became actual friends. I started attending HOA meetings occasionally, just to keep an eye on things and make sure no one else was being treated the way I had been. In January 2027, the board held elections for new members. David asked if I would consider running. I thought about it seriously but ultimately declined. I had no desire to get that deeply involved in HOA politics. But I did agree to serve on the Architectural Review Committee, where I could help ensure that future requests were handled fairly and legally. My flag still flies outside my house every day. I raise it every morning when I leave for work and lower it every evening when I get home, just like the flag code requires. During the first week of March 2027, I installed a small spotlight so I could leave it up at night, properly illuminated as the flag code permits. No one from the HOA said a word. On Memorial Day weekend, I organized a small ceremony in the neighborhood park. About 30 people showed up, including David Martinez and several other veterans who lived in Saguaro Springs. We raised the flag together, observed a moment of silence for those who had died in service, and then shared stories over burgers and hot dogs. It was the kind of community moment that HOAs are supposed to foster, neighbors coming together around shared values. It struck me as deeply ironic that it had taken a 6-month legal battle to get here. In June, I received a letter from Congressman Greg Stanton, who represents Arizona's 4th District. He had read about my case and wanted to introduce legislation that would strengthen the freedom to display the American Flag Act by explicitly prohibiting HOAs from imposing procedural hurdles like mandatory pre-approval. He asked if I would be willing to testify before a House subcommittee if the bill moved forward. I agreed immediately. The idea that my personal struggle could help protect other veterans and service members from similar harassment was incredibly meaningful. Robert helped me prepare written testimony, and we traveled to Washington, D.C. in early August for the hearing. The hearing room was ornate and intimidating, with high ceilings and dark wood paneling. I sat at a long table facing the subcommittee members, with a microphone and a glass of water in front of me. Robert sat directly behind me in the audience section. I testified for about 15 minutes, walking through my experience with the Scottsdale Springs HOA and explaining how the existing law had ultimately protected my rights, but only after significant time, stress, and expense. I argued that no veteran should have to hire a lawyer and file a federal lawsuit just to fly the American flag outside their home. Several subcommittee members asked questions. One representative from Texas asked whether I thought HOAs served any legitimate purpose or whether they should be abolished entirely. I explained that I believed HOAs could be beneficial when they focused on maintaining common areas and resolving genuine disputes between neighbors, but that they often overstepped their authority and needed clearer legal boundaries. Another representative from California asked whether my military service had influenced my determination to fight the HOA. I thought about that question for a moment before answering. "Ma'am, I joined the Marines because I believe in service and sacrifice," I said. "I deployed twice to defend the freedoms that Americans enjoy, including the freedom to live in a country where you can fly the flag without fear. When I came home and bought a house, I never imagined I would have to fight for that same freedom in my own neighborhood. But once I realized what was happening, I knew I could not back down. If I let them take away my right to display the flag, what message would that send? That our rights only matter as long as no one challenges them, that we will surrender our freedoms to avoid conflict. I could not accept that. The room was silent for a moment after I finished. Then the subcommittee chairman, a veteran himself, nodded slowly. "Thank you for your testimony, Mr. Thompson. And thank you for your service, both overseas and here at home." The bill did not pass that session. It got bogged down in committee politics and competing priorities, but the hearing generated media coverage that brought more attention to the issue. Several states introduced their own legislation to reinforce flag protection rights, and at least 3 passed stronger laws by the end of 2027. Back in Scottsdale, life continued. I got a promotion at work in September, which helped me rebuild my savings after the legal expenses. I started dating a woman named Jennifer who worked as a teacher at a nearby elementary school. She thought the whole HOA fight was hilarious and called me her flag crusader. In November, I was invited to speak at a legal conference in Phoenix about HOA disputes and federal law. Robert convinced me to do it, arguing that sharing my story could help other attorneys who were representing homeowners in similar situations. I was nervous about public speaking, but the audience was small and friendly. Several attorneys came up afterward to ask questions and share their own HOA horror stories. The holidays that year were peaceful. Jennifer and I hosted Thanksgiving at my house, and several of my neighbors came over. David Martinez brought his wife, and we all stood in my front yard looking at the flag lit up against the dark sky. "That is a good-looking flagpole," David said with a slight smile. "Worth every penny of legal fees," I replied, and everyone laughed. In January 2028, nearly 2 years after the dispute began, I received a surprising piece of mail. It was a handwritten note from Patricia Henderson. The envelope had a return address in Sun City, and the handwriting was shaky but legible. "Dear Marcus," it began, using my first name for the first time. "I hope this letter finds you well. I have been doing a lot of thinking since I left Scottsdale Springs, and I owe you a more personal apology than the one the board provided. I was wrong to confront you about your flagpole. I was wrong to call it an eyesore. And I was wrong to push the board to fight you instead of recognizing that you had every right to display the flag. I let my desire to control the neighborhood blind me to what really mattered. You served our country with honor, and instead of thanking you, I made your life difficult. I am truly sorry. I hope you can forgive me. Sincerely, Patricia Henderson. I read the letter several times, feeling a complex mix of emotions. There was satisfaction in receiving this personal acknowledgement of wrongdoing. But there was also sadness that it had taken so long and cost so much for her to reach this understanding. I wrote back a short response. Patricia, thank you for your letter. I accept your apology. I hope you are finding peace in your new home. Marcus. I never heard from her again, but I kept her letter in a folder with all the other documents from the case. The threatening notices, the legal filings, the settlement agreement, and the board's formal apology. It was a complete record of a fight I never wanted but was glad I had won. In February 2028, Jennifer and I got engaged. We decided to hold the wedding ceremony in my backyard that June, right under the flagpole. It seemed fitting. The flag had caused so much trouble, but it had also taught me an important lesson about standing up for what is right, even when it is difficult and expensive. The wedding was small and intimate, just close friends and family. David Martinez officiated using his online ordination from some ministry website. During the ceremony, he made a reference to the flagpole dispute that got a big laugh from everyone who knew the story. Marcus and Jennifer, you are beginning your life together in the shadow of this flag, David said, gesturing toward the red, white, and blue banner waving gently above us. This flag represents freedom, justice, and the courage to fight for what you believe in. Marcus demonstrated that courage when he refused to back down from an unjust demand. May you both carry that same courage into your marriage, standing up for each other and for your shared values, no matter what challenges you face. Jennifer squeezed my hand, and I felt my eyes sting with unexpected emotion. It had been a long journey from that Saturday morning when Patricia Henderson marched across my lawn. There had been stress, conflict, expense, and moments when I wondered if it was all worth it. But standing there in my backyard, surrounded by people I loved, with the American flag flying overhead on a pole I had fought to keep, I knew the answer. It had absolutely been worth it. After the wedding, Jennifer moved into the house with me. She brought her own touches to the space, artwork on the walls, new furniture in the living room, plants on the back patio. But she insisted that the flagpole and flag stay exactly where they were. That is not just a flag, she told me one evening as we sat on the front porch watching the sun set. It is a symbol of who you are, a reminder that some things are worth fighting for. In August 2028, I received notification that Congressman Stanton's flag protection bill had been reintroduced with broader bipartisan support. This time, it included specific provisions prohibiting HOAs from requiring pre-approval for flag displays protected under federal law, and it increased the penalties for violations. The bill passed the House in October and the Senate in December. The President signed it into law in January 2029. Robert called me when he heard the news. You did it, Marcus. Your case helped change federal law. We did it, I corrected him. I could not have done any of this without you. Well, it was an honor to represent you, Robert said. Not many cases make that kind of impact. The new law went into effect in March 2029, 3 years after my original dispute with the HOA. News outlets picked up the story again, and I did several interviews about how my personal experience had contributed to the legislative change. Some of the coverage was over the top. One cable news segment called me the man who took on his HOA and changed America. But the core message was accurate. One person standing up for their rights can make a difference. In April, I was invited to speak at a Veterans Affairs event in Washington. Jennifer came with me, and we made a weekend of it, visiting the monuments and museums. At the Lincoln Memorial, standing beneath the massive statue of the 16th president, I thought about the words carved into the marble. Government of the people, by the people, for the people. That is what the flag represents. Not blind obedience to authority, but the right of ordinary people to govern themselves, to challenge injustice, and to demand that their rights be respected. My fight with the HOA had been a small-scale version of that larger principle. Patricia Henderson had tried to use her authority to force me to comply with an unjust rule, and I had refused. The system had worked, slowly and imperfectly, but it had worked. Back in Scottsdale, things were quiet. The HOA operated smoothly under David Martinez's leadership. There were occasional disputes. Someone complained about a neighbor's Christmas decorations. Another person objected to a fence that was 6 inches too tall, but nothing that escalated to legal action. The board had learned its lesson. In May 2029, Jennifer and I found out she was pregnant. We started planning for the baby, converting the spare bedroom into a nursery and reading every parenting book we could find. One evening, as we were assembling a crib, Jennifer asked me what I wanted to teach our child about the flag. "I want them to understand what it means," I said, tightening a bolt on the crib frame. "Not just as a symbol, but as a reminder of the responsibilities that come with freedom. The flag represents ideals, equality, justice, liberty, but those ideals do not maintain themselves. Every generation has to fight for them in their own way." "Do you think you will tell them about the HOA?" Jennifer asked with a smile. "When they are older, definitely," I said. "It is a good lesson about standing up to bullies, even when the bully is an institution with lawyers and money." Our daughter, Emma, was born in January 2030. She was perfect and tiny and screamed at incredible volumes. Jennifer and I stumbled through those first exhausting months of parenthood, learning how to function on 3 hours of sleep and discovering depths of love we had not known existed. When Emma was 6 weeks old, I carried her out to the front yard on a sunny morning and stood beneath the flagpole. She was wrapped in a blanket, her eyes squinting against the bright Arizona sun. The flag snapped in the breeze above us. "That is the American flag, Emma," I said softly, even though she was too young to understand. "Your daddy fought to keep it flying here. And someday, when you are older, I will tell you why that mattered." She yawned and fell asleep in my arms, completely unconcerned with flags or HOAs or federal laws. And that was exactly as it should be. My fight had been to ensure that she could grow up in a place where certain freedoms were protected, where the government could not silence expression or prevent people from displaying symbols of patriotism. In March 2030, 4 years after the dispute began, I received a final piece of correspondence related to the case. It was a letter from a law student at Arizona State University who was writing a paper about HOA law and the Freedom to Display the American Flag Act. She asked if I would be willing to be interviewed for her research. I agreed, and we met at a coffee shop near the ASU campus. She was bright and earnest, with a dozen questions about every aspect of the case. I walked her through the entire timeline, from Patricia's initial confrontation to the settlement and beyond. "What would you say was the hardest part?" she asked, taking notes on her laptop. I thought about that. "The uncertainty," I said finally. "Not knowing if I was doing the right thing, if the expense was justified, if I would win." There were moments when I thought about just giving up and moving the flagpole to the backyard where no one would see it. But then I would remember why it mattered, and I would keep going. "Do you have any regrets?" she asked. "No," I said without hesitation. "I wish it had not been necessary." I wish Patricia Henderson and the HOA board had just respected federal law from the beginning, but I do not regret fighting. Some things are worth the cost. The law student finished her paper and sent me a copy. She got in on it, and a version was later published in the Arizona State Law Journal. I was cited multiple times and even quoted in the conclusion. It was strange to see my personal experience reduced to footnotes and legal analysis, but also gratifying to know that it was contributing to legal scholarship. Life moved forward. Emma grew from an infant into a toddler, babbling constantly and getting into everything. Jennifer got promoted to vice principal at her school. I continued working at the telecommunications company and took on additional responsibilities, managing a team of technicians. The flagpole remained exactly where I had installed it on that Saturday morning in March 2026. The original flag wore out after a couple of years, and I replaced it with a new one. I maintained the flagpole carefully, tightening bolts and checking the bracket to make sure everything was secure. Every Memorial Day and Veterans Day, I held small ceremonies in the neighborhood. More veterans started attending as word spread, and it became a tradition that people looked forward to. David Martinez always came, and he usually said a few words about service and sacrifice. At the Memorial Day ceremony in 2031, David pulled me aside after the formal program ended. "You know, Marcus, I have been thinking about that whole flagpole situation. It changed this community more than I think people realize." "How so?" I asked. "Before that dispute, the HOA was kind of a joke," David said. "Patricia ran it like her personal fiefdom, and everyone just went along because it was easier than fighting. But you showed people that you could push back, that the HOA was not all-powerful. Since then, we have had much more engagement from residents. People come to meetings, they ask questions, they hold us accountable. It has made us better." I had not thought about it that way, but David was right. The neighborhood had changed. People were more aware of their rights, more willing to challenge authority when necessary, more engaged in community governance. My fight had been about a flagpole, but the impact had been broader. In June 2031, Jennifer and I found out she was pregnant again. Our son, Michael, was born in February 2032. Emma was fascinated by her baby brother and insisted on helping with everything, from diaper changes to bottle feedings. When Michael was a few months old, I carried both kids out to the front yard and stood beneath the flagpole, just as I had done with Emma. The flag was flying at full staff, brilliant red, white, and blue against the cloudless Arizona sky. "This is important," I told Emma, who was now old enough to sort of understand. "The flag represents our country. It means we are free to say what we think, to believe what we want, and to stand up when something is wrong." "Why is it on our house?" Emma asked in her small, curious voice. "Because I wanted everyone to see it," I said, "and because I fought for the right to put it there." "Did you win?" she asked. I smiled and looked up at the flag waving in the breeze. "Yes, sweetheart, I won." That flag still flies today, a reminder of a 6-month battle that tested my resolve, strained my finances, and ultimately vindicated my rights. The cost was $1,890 in legal fees, plus countless hours of stress and worry. But the value was incalculable, the knowledge that I had stood up for something that mattered, that I had refused to be bullied, and that I had helped strengthen the legal protections that ensure every American can honor their country by displaying its flag. Every morning when I leave for work, I glance up at that flag. And every evening when I come home, I see it waving in welcome. It is more than just a piece of cloth on a pole. It is a symbol of freedom, a testament to perseverance, and a reminder that ordinary people can make a difference when they refuse to back down from what is right. The HOA tried to take it away. Federal law protected it. They apologized and paid my legal bill of exactly $1,890. And the flag still flies, as it always will, outside my home in Scottsdale, Arizona.